Welcome to TeleGeography Explains the Internet, the show that explores the business behind all of the ways humans stay connected around the world. I'm your host, Greg Bryan, and my guest today is Jeff Long, who is an attorney in private practice with a focus on data centers and the telecom industry. I was really excited to conduct this interview with Jeff, as telecoms is a heavily regulated industry, and U.S. law in this area has taken many turns and holds complexities that I think have a real impact on how the industry works. While I know many of our listeners are not in the US, certainly our laws here and regulations have reverberations around the world as well, so I think it'll still be generally interesting. We start out with a historic review of telecom law in the US, going back to plain old telephone service more than 100 years ago, and the AT&T monopoly that eventually was broken up. We talk about the 1996 Telecom Act, which is still the last big legislation about the internet and telecom, and the issues around Title II and net neutrality. This becomes especially important now that the Supreme Court of the United States has overruled a case about deference to administrative agencies that really could have a major impact on the FCC and telecom regulations. So it's going to be a space to watch. We then get into spectrum allocation and some classic law and economics analysis that actually impacted how the US and other governments around the world have allocated their spectrum to various users. We had hoped to get to data centers, but alas, ran out of time. So I hope sometime we can have Jeff back on in the future to dive into the many legal issues in that market. This was a very fun episode for me to nerd out on these topics that I have long been interested in, and I hope you enjoy and maybe learn something along with me. Okay, welcome to the show, Jeff Long.
Thank you for having me.
All right, so it's my pleasure. We've talked about this topic, just the two of us before, and when we were, I thought, hey, this would we get a chance to listen into. But before we dive into what that topic is, I've set it up in the intro here a bit, but could you just give us your background and how you ended up getting funneled into telecom law? For people outside the law world, of course, like everyone just thinks that lawyer is a particular profession. It's really very variable, right? If I can use overemphasis there on what you could focus on.
Definitely.
So how did you get to telecom law?
No, there's all sorts of stuff that lawyers do that I wouldn't know the first thing about. Actually, it's in the nature of the work. But so when I was a student, I loved law and economics, and I loved economic history. From my days before law school. And it turns out that when I got to law school for that reason, I got really into topics on regulated industries and antitrust. Like the big microeconomic models, but macroeconomic industries, nationwide, huge markets. And ended up working after law school for a judge and then a law firm that were pretty renowned for their work in telecom. And telecom is kind of like the most important and I'd say most interesting of those highly regulated industries that we have in the U.S. So it's kind of a natural thing to undertake when I went to work for a law firm. And subsequently, I've been in private practice and done some telecom work and worked for clients in the industry. And just find it, in addition to professional possibilities and opportunities, just endlessly fascinating, which is what brought me to you, Greg, and to this outstanding podcast. Right?
Thank you.
Your exploration of the internet was extremely helpful to me facing a particular legal issue.
Yeah. So. Excellent. Yeah. All right. And so, we're going to be talking about telecom law.
Sure.
Certainly a lot of folks that are the audience of this podcast are in the U.S. Many of them are not as well. And we do have reach beyond that. However, a lot of these issues, I think, do have some global applications in thinking about how they play out in other places. And also, for better or worse. A lot of times the developed world takes its cues on regulation from the U.S. Market as well.
Absolutely.
So even though we're focused on
Yeah.
the U.S., I think there's a lot of things here that are interesting for the rest of the world, especially as we're going to get into the history of all of this. I think, telephone systems were developed in the U.S.
Absolutely.
and how to think about those, right? So,
No, Greg, you nailed
Mhm.
it. The new iPhone charger port. Are you
Mhm.
familiar with why we've made this switch?
No,
It
please,
turns
yeah,
out, that European regulators, this is obviously more on the consumer-facing side,
right,
the cellular industry. They demanded that Apple switch its phones to meet this common standard
right,
on the
exactly,
continent. And Apple figured, we could keep producing one phone for the U.S. and one phone for Europe, but that wouldn't
hmm
be plausible.
right,
All right, so
right.
it's just a classic example of how all regulation is global these days.
Exactly. Yeah, that's a great point. That's a great point. All right. So I want to start, Jeff, with some history
Yeah.
because I actually am
Okay.
really interested in this history. And I think that it has lessons about the internet embedded in that history, right? Is that you really can't
Yeah.
untangle internet policy and things like we had talked about before, data centers and whatnot, from plain old telephone service, right? From the regulations that arose out of the growing telephone business that was happening more than a century ago now. So I wonder if you could start there for us and maybe tell us maybe the right starting point, and you can correct me if I'm wrong, would be to tell us why AT&T was
Sure.
allowed to start a monopoly, since you're talking about law and economics and antitrust issues, right? Here's where
Sure.
they intersect directly.
Greg, you're absolutely correct. And the truth is that, especially in an economy as dynamic as America's over the last couple of or last century and a half, there's a tendency of the technology to run out ahead of the regulation. So we
Hmm.
look to telephone policy as something which ultimately was inherited as modern day internet policy because it's what was in place when
Right.
the internet first emerged. Right. So the thing about telephones and their and telephone service is that, like a lot of other things that we deal with in law and economics and in the regulation of highly regulated industries, is that a telephone network needs to be huge before it hits its
Mm-hmm.
minimum efficient scale,
Right.
which means in order to provide services efficiently, you need a really, really big part of the market.
Right.
Right. So it's a little like there's the old story of the guy who gets on the phone with the telephone operator and places a call, and the operator says, "Okay, that'll be 10 cents," and the guy says, that was nothing. It required just a ping of your wire, 10 cents, and the operator says, "No, the $1 million that went into building the network and 10 cents, the million and
Right.
10 cents is what it costs to
Exactly.
place the call." Right. So in order to recoup the huge capital investments required to provide telephone services, these markets lend themselves to a minimum efficient scale of 100%, which is to
Hmm.
say it may make sense for everybody for there to be telephone service, but it may not make sense for more than one provider to build in any one particular area. Right. And
Right.
then that natural monopolistic tendency of telephone markets, as they originally were, it's only exacerbated by network effects, which you guys deal with even today in broadband provision, which is to
Absolutely.
say, the more connections a network's got, the more valuable one additional marginal connection is, even as compared with another network, right? One
Right.
additional customer will find a built out network way more attractive than a limited one. So as a
Hence
result,
why Ashburn
yeah,
is a name on the map in the telecom world.
yeah,
That's
that's
along
that's
the
exactly
lines of
right.
Frankfurt, London, Singapore, et cetera.
Yep.
Right? Yeah. Yeah.
Yep. And the thing is about these concepts, right? Whether it be like, the minimum efficient scale, what that does to competition, network effects like you guys are dealing with in data centers, transport networks writ large, they represent themselves in every industry. So
Hmm.
it was an issue for telephones. It had been an issue for, the telegraph before it. It's an issue, for broadband. And, we'll see it again and again and again. It's one of those basic recurring economic problems
Hmm.
and opportunities.
So how did that play out specifically for AT&T? If for folks who are
Yeah,
old enough, right, that
yeah,
lived in the U.S., AT&T was
yeah,
the telephone company, but they
yeah,
weren't always
Yeah.
the only telephone company, of course, right? There were thousands, as there still are, hundreds at least of ILECs in the U.S. But take us through that history
Yeah.
a bit of how AT&T got the
Sure.
imprimatur to become a monopoly.
Again, across several, that's absolutely correct. So,
Yeah.
internet policy today, it's full of terms and jargon that really arose over like last 150 years of
Mm-hmm.
regulation of telephone services. And, that 150 years of regulation is part common law courts, and it was part state regulatory commissions and utility regulators, and then eventually Congress, right? But it created this dense body of rules that together, precedent and operative law today form what we call telecom law, right? So the
Mm-hmm.
law is the history, and in a lot of ways, the law and the history are the economics here.
Right.
Because in the United States, in the Western tradition, we've always embraced free private enterprise.
Mm-hmm.
The idea being that private firms will compete with one another, lower quality and increase quality, lower
Right.
price, innovate in order to do both of those things. And usually
But
it's the
that gets
antitrust.
hinky, right, in a market
Yeah,
like telephones, where
that's right.
hanging wires or digging trenches is kind of what we call in economics a natural monopoly, right? So,
Yeah. Hey, you nailed it. Exactly. So, telephone services and the regulation of telephone, which forms the basis of internet law and policy today,
Mm-hmm.
it arose from the telephone industry, which is given to monopolistic markets where there can't be competition. Right. So, for a tradition that values competition to drive down price and up quality, the question is, what do we do with these telephone services, which seem to be, natural monopolies?
Right. Right. So that brings us then to the AT&T situation, right? So
Yeah. Yeah.
anybody listening who's old enough, who grew up in the U.S., right? You might have thought of the AT&T as the telephone company, and then later the Baby Bells or whatever. Could you take us, just quickly through
Sure.
that kind of history of how we got
Yeah.
AT&T monopoly, and then how we got to where we are today?
Sure. So AT&T initially was very successful in consolidating local telephone networks, regionally or city, or increasingly as the service was built out, larger, what we think of as metropolitan areas and service areas.
Mm-hmm.
And they were able to use the naturally monopolistic nature of telephone service in order to monopolize the market nationally. And that happened in the early 20th century. And along with that overall national consolidation of service under one company, they were also very aggressive about, and they invested a lot in acquiring the necessary patents to make their telephones work.
Mm-hmm.
And as a result, what they had was kind of they were well suited to the natural monopoly that the market offered itself up as.
Mm-hmm.
So that's where we got into what came, Well, go ahead, Greg. Next question. We're doing better when you guide me along.
No, that's really interesting. Okay, so and first I'll bring up that it's interesting that maybe
Yeah,
Bell Labs becomes a part of all of this, right?
that's right.
Yeah,
Yeah, we're
so
going to talk later about when AT&T is broken up
mm-hmm.
and how important it is to the consent decree
Right.
that Bell Labs is separated out. Right.
Well, yeah, no, I think that's where we could go now. So
Okay. Yeah.
so you say AT&T is a monopoly
Yeah.
around 100 years ago. That remains to be
Yeah.
the case for
Yeah.
decades. Then we get to the 1980s, where I'm a kid of the 80s, so I remember Southern
Sure.
Bell. I grew up in Florida, right? So
Yeah.
so how did we get from AT&T basically being the telephone company to the sort of our box, and you can tell us what that means,
Sure.
right? And what came in the 80s there.
No, this one. So the breakup of AT&T, it took, or at least the breakup of the what had previously been a kind of national monopoly. It took place really over like a 30-year period.
Interesting.
Is the
Okay.
better way
Yeah.
to think about it.
Mm.
But initially in the 1980s, after filing suit in the 1970s, the Justice Department reached what's called a consent decree with AT&T, where AT&T agreed to break itself up. And what it did was it broke itself into Baby Bells, as you mentioned, which is a little bit, like like maybe like the king in Game of Thrones, declaring that he's dissolving the kingship, and then everybody takes over their own domain. There were baby bells for each region that had priorly all been owned commonly. So it didn't do as much in that respect to solve the problem of monopoly within a region.
You've just done regional monopolies instead of a national monopoly, essentially.
That's right. And at a minimum, the regional monopolies could compete with one another for long distance service. So and then the other pro-competitive piece of breaking up this monopoly, Greg, was just what you mentioned. They were able to separate out some of those patents, which were necessary to, top-rate service, from the national monopolists, which enabled more competition at what back then was the edge.
To give you I like that. Yeah. That's really interesting. So, and I'll skip, even though I want to, Jeff, because it's fun to get into things like the Hushaphone case and all that. But that's probably beyond the scope of this podcast. But anybody listening, you can Google that and see it. It had some implications later. But in the interest of time, let's then move on to what I'm under the impression, and you can disabuse me of this or not, that really the last time Congress really meaningfully legislated about, if I can say that way, about the sort of telecom world was 1996. First, is that still really the case? And secondly, what was the 96 Act and what are kind of its implications?
Sure. And Greg, spot on again. You know more than you let on. But yeah, that was the last major legislation from Congress in regard to the telecommunications industry. And that was an amendment to the 1934 Communications Act.
That is really interesting, isn't it? Yeah.
And
it's not even its own act, right? Yeah.
No, it's not. No, 1996, those were amendments. But it was amendments to like the Bible of telecommunications law, because the 1934 Act was the one that had created the FCC and empowered it to begin making and enforcing rules per the overall instructions that Congress gives it in statute. All of which is to say there wasn't a major revision of the 34 Act until 96. But in that period, the FCC was undertaking its administrative role of creating rules and enforcing them and then canceling rules. And that's why telecom has become such a heavily administrative area of law, where most of the litigation, where most lawyers are working at the FCC rather than in a courtroom.
Gotcha. Okay, so anybody in the telecom world, has heard talk about sort of Title II and that section of the 1996 Act. Could you just tell us sort of what Title II is and why that is a meaningful sort of issue?
Yeah, sure. So the telecom industry, communications industry, governed by the earlier Communications Act from the 20th century, and they're both updated in 1996. So as it currently stands, it makes a division, and back then it tried to make a division between two general categories of services and the regulation of them. In the first bucket, and the terms get confusing. You have traditional telephone services, which the federal government, through the law and authorizing the FCC to enforce, the federal government declared that a universal service would be available to everybody, and that telephone rates, kind of like back in the 20th century, throughout the 20th century, that telephone rates would be regulated for a fair, reasonable price. The kind of natural monopolistic regulation that we were used to seeing for telephone services, and then also allowed for a separate, and we call those Title II services, and allowed for other services outside of that old monopolistic telephone service realm, and offered that unregulated. So when you hear people talk about the 96 Act and amending the Communications Act in the 30s, we talk about net neutrality or anything else. You hear Title II, and it's an invocation of the old school rate regulation of the old telephone monopoly. and stuff that does not fall within the ambit of that is not subject to those rules and that kind of regulation.
And what specifically are those regulations? So
Sure.
Whether you want to fall under one or the other, yeah.
So Title II rules are actually those that we're used to seeing for monopolistic type industries all throughout the last 200 years. And indeed, we adopt in telecom in Title II that inheritance of the old common law and earlier industries, all of which is to say, when Title II services are being provided, there's a requirement that they're provided at a fair and reasonable rate. The fair and reasonable rate is usually set not by market pricing, not by bidding or action between private bargainers, but by a regulator.
Right.
And you're required to offer non-discriminatory services, which means you're not allowed to offer different rates to different users. In this context, we're referring to like a business use versus a personal use. And you're also required to make your certain facilities that are central to the network. Think about like a switch, an important switch somewhere that is the only way for traffic to get from one spot to another.
A central office that's on a core line or something like that. Yeah.
That's right. That's right. So that's Title II stuff. And it's what we think of as utilities type stuff. So the question is, are we going to, or at least the authority to do type utilities type stuff, even if the FCC kind of forbears on it, right? So the question now is we have these new emergent services spurred by innovation. Which category do they get put into? If you get put into Title II, then you can be regulated, like the old AT&T Ma Bell companies.
Right.
If you stay out of that category, this is what's called information services, then you're not subject to that regulation.
So this is where the rubber meets the road, I think. So I think, so it's 1996. You're updating an act from 1934. It's about the telephone system. As much as I have harped on, you can't understand the internet without understanding telephones first, and maybe even telegraphs to some extent before them. It is also the case that they are different, right? So we have to remember that in 1996, I was actually in my first year of college, and my entire dorm had a T1, 1.5 megabits, right? You know what I mean? What you could do, my email system at university was Pine. It was like what you would look at as like a terminal window now, like coding. You know what I mean? So, the way that the internet was consumed and its purposes or whatever were very different in 1996, right? Then even if you fast forward to, I want you to talk, of course, about the Brand X Supreme Court case, which was the early 2000s or 2005 or so, right?
That's right.
The internet had still developed a lot by then, but most people at that time, even the United States, did not have broadband. They were usually getting the internet through dial-up, for example. And so
it was mostly running over telephone lines.
That's a really good point. That were subject clearly to Title II, right?
That's
so
right.
You're like, if you're twisted pair, right? Everybody listening should know, sort of what a twisted pair is. And then you have this complication with overbuilders, cable companies that already owned wires in the form of coaxial cables to homes, wanting also to get into the internet game. So you put all of this into a kind of stew, right? And it boils over into Brand X. So what happened in Brand X? And I'll preface this by saying that of all of the Supreme Court cases one might read, if you read this sometime after 2005, or maybe as a savvy internet user in 2005, you might find it frustrating, as I certainly did.
Yeah.
Right.
So what happened in 1996 is Congress, in addition to trying to open up competition on telephonic services, was trying to figure out how to deal with this other category of information services, which, like you said, were kind of like telephonic services, but kind of not, right? Especially to the extent that they were purely data without the need, for voice conversion on one end or another. So Brand X concerned the question as to whether a particular service being offered by I believe it was a cable company, it was like a form of dial-up internet, whether it fell on one side of this line or another, whether it was a telephonic service or an information service. And Brand X is famous because the FCC decided to put this particular service on the non-Title II side of the fence. And an earlier court decision, I believe it was out of the Ninth Circuit, had placed it on the other side of the fence. So the FCC was kind of defying a prior court's interpretation of how to apply these categories. And it was appealed up to the Supreme Court. And very famously, in Brand X, Justice Thomas, writing for the majority, ruled that the FCC is given flexibility to change its interpretations, and it's given some breadth in how it interprets operative language here, like information services versus telecommunication services,
right?
And that it was at liberty to defy a prior court's determination of the meaning of these statutes and its own, if necessary, and that was because of something called Chevron deference.
Right.
So what Brand X was doing was giving to the FCC its a very broad Chevron deference to make its own determination about where services will fall on either side of the line.
And to be clear, the sort of impact of that on the telecom business would mostly be about net neutrality. Is that the case?
Well, it's actually it animates the net neutrality public debate, but it has an effect on everything the FCC does. And what it means essentially is that if a statutory command is not going to have one fixed meaning, but is going to be subject to the FCC's interpretation, and the FCC is allowed to change its interpretation, provided it provides good reasons for it. That makes any question of policy not a matter of a congressional statute. It makes it a matter of how the FCC handles the congressional statute. Right?
So you have the situation we've been in where FCC of a particular administration makes a rule, the next one comes along and undoes that rule, the next one a little bit of a roller coaster of net neutrality is the one that folks follow, but I imagine this has an impact on things like local loop unbundling as well and things like that.
No, that's right. That's right. And what the telecom industry is an exceptionally complicated industry with a lot of actors, it's more complicated than obviously a lot of other industries. Just in terms
I
of
think everybody listening probably agrees with you on that.
I mean, so and everyone thinks it's their industry, but no, it's real here. The thing is about these statutes, Greg, is that they're written broadly. So what's a fair and reasonable price for a data packet, like you mentioned in your explanation of the internet, that travels around the globe and through 500 devices? That's not so easy. So you got to fill in those gaps. And then also we have, as you mentioned, very little legislation, and we have an industry that reinvents itself every year. And every 10 years, and before you know it, it's no longer phone service, it's data. Before you know it, it's I was listening to the an earlier transport explanation episode, and the WDM, is that what it's called? And the multiplexing?
DWDM, wavelengths.
DWDM, so that is like Star Trek stuff. To the night, back in '96. A lot of this just didn't exist. So the point that I think I'm getting at is that the technology outruns the legislation so quickly, the words that are used so quickly, that it's left for the agency to apply these prior laws, dictating that ILECs, allow competitors in, and that define things like information service and telephonic services. They got to apply that to modern day technology innovation, and that leaves a lot of discretion. So in net neutrality, for instance, the FCC under Brand X had been with after providing sufficient reason, showing its homework, essentially permitted to come out on either side of the question as to whether internet service providers today are subject to Title II regulation, and allows things to flip back and forth. But there's a quick follow-up here and an interesting note. Chevron, upon which Brand X was based, was recently overturned That
I mean,
happened
by
just this year.
recently, we're
Yeah.
recording this in August of 2024.
Yeah.
This happened just a few months ago, right? So, in fact, when I
Right.
first started working on the outline for our conversation here, that case had not come down yet.
Yeah.
So I didn't
That's
know what
amazing.
we would end up talking about when I
Yeah.
yeah.
Yeah, no, and it's important. Chevron coming down, in effect, being overruled, obviously leaves the brand X approach that that had allowed the FCC a lot of discretion, leaves that in question.
Right.
It's not so clear that the FCC is going to get to make its own choice as to whether modern internet service should be regulated as a Title II service or not.
So explain that to me a little bit more if you could. So I forget the name of this case that just came down, but would that mean that Loop? Okay, yes. Yeah, okay, gotcha. So would Loper mean that essentially
Loper Bright? I think
Loper Bright. Okay, gotcha.
It's a shorthand.
Yeah,
Loper Bright.
So absent new legislation, right, updating the 96/34 acts, right?
That's right.
It will be the court system that places telecoms in Title I or II instead of the FCC. Essentially, is that the correct interpretation of that? Okay, gotcha.
Yeah, no, that's right. And just to link it up with the administrative changes that you mentioned, the FCC will take a position. Like the Biden FCC is doing at the moment, and kind of plant its flag and declare, we think modern internet services ought to fall under Title II, and regulated like AT&T telephone was regulated in the 20th century.
Which would mean like local loop unbundling potentially if they decided to do that. Would mean net neutrality,
rate
like
regulation.
Tariffs,
it would mean that's right. So, here in particular, because a lot of those concepts no longer apply, right? They were for older technology, but here what comes up often is throttling and prioritization. Right. So it most often takes the form, and I think the economics are dubious, to be frank, but the argument is that it could be damaging to the market and hurtful to consumers if internet service providers were able to throttle one party's traffic for whatever reason, because they're speeding somebody else up, or to give a paid prioritization to bandwidth. When you face capacity limits. But here, what's going to end up happening is the FCC is going to declare that internet services are within Title II or can be regulated as such. And then a company is going to sue, claiming that the statutory language simply won't bear that interpretation that the FCC is taking, the construction that they're putting on the law. And it'll go up to the Supreme Court, and the Supreme Court will no longer get to say, well, so long as the agency isn't completely, off its rocker, so long as it seems reasonable, then where reasonable minds can disagree, the FCC gets it.
But that's instead they'll have to interpret the statute and apply. I see. Right. Okay, that makes sense. And to be clear for anybody listening who's not a nerd about this kind of stuff, the parties involved here, broadly speaking, and correct me if I'm missing something here, but would be in this case, if the current FCC says we're going to enforce a neutrality on the internet, the parties suing that would most likely be the carriers, right? So like ILX and the other parties, as it were, right, who might be filing friend of the court briefs or whatever on the would be content providers. So this is kind of the age old carriers versus content kind of thing.
Yeah.
Gets into a lot of other areas of the economics of the internet too, but is that's pretty much the case here?
No, that's right. But it's also the kind of, and never say never, okay? And just like, things represent themselves, essentially when they result from fundamental economic dynamics. But the most of what was expressed as a concern, Greg, actually back in like the 2010s. During the end of the Obama administration, and then it was the Trump administration FCC that overturned what had been the net neutrality rule. Right. Most of the issues cited during that debate have been innovated out of by now, 10 years on. So certain limitations in bandwidth, certain interconnectedness issues that animated that debate have actually been rendered a non-issue because the technology is just blown past it.
And then, I think that brings a really interesting point about, the difference in regulating an industry like telecom versus an industry like, just for example, another heavily regulated industry would be like banking, for example, right?
That's right.
The process, and I'm no expert on sort of monetary stuff, but the process of banking is essentially the same throughout all time, right? It's like there's interest rates and there's amounts that you can hold and all that. Whereas like telecom is hard. It is constantly innovating. And they're constantly trying to work around these problems. So I can see why this is a vexing sort of area to focus.
And there's no innovation these days in any other industry, be it banking or anything else, without telecom. It's just so essential.
Yeah, if banking changes, it's because of the internet, right? It's
that's right. That's right.
Absolutely.
And it's where innovation is the fastest. Right. And that just it makes the law and the regulation of it exceptionally confusing, and it also it presents just certain difficulties because, as you mentioned, the banking industry doesn't outrun the present day banking conditions faster than telecom does. Within 10 years, technology which used to dominate the market will disappear. It'll no longer be useful. It's just
one of the things I talk about all the time. In fact, I remember way back in the day when this is maybe 15 years ago, there was a net neutrality argument. There's always a net neutrality argument going on, and some people worrying about how it might impact MPLS, because the whole way that MPLS worked, what was important about MPLS is that you could put headers on packets that determined that those packets which you paid more per bit for got to go to the front of the line. That's strictly speaking not neutral, and the FCC was made aware of this, and people try to work around that. But it just goes to show MPLS is not that important anymore. It was the center. It still exists, and it's but as there will always be work for those who are interested in telecom regulation and analysis, right? Because it's constantly changing. So.
No, and the demand isn't going anywhere.
Right. That is another great point. So that's a great segue for we're running low on time here, Jeff, but I want to make sure we hit this because I really like this topic, and I think you might have something to say about it as well, which is spectrum. So demand is not going anywhere. We've been talking almost exclusively about wireline service and the difficulties that go with that. My particular pet sort of issue with spectrum is this, and being a law and economics guy, you can do a much better job than me, I think, in explaining this famous paper in the law and economics world.
Not assuming happens. Not if this episode's any indication. I'm sorry, go ahead.
No. It's so it just so happens that one of the more famous papers in the law and economics world is about telecoms. It's about allocating spectrum for the use of transmitting information and data by a guy named Ronald Coase, who is an economist and wrote a few important papers that people cite often, all about the most efficient way for a society, right, to allocate spectrum. Because in case anybody doesn't know, spectrum is a limited resource, just like anything else. There are parts of the spectrum real estate map that are better for doing certain things, right? My pet peeve about this, Jeff, is that some of the choicest real estate, what would be downtown or beachfront property in that spectrum, right, belongs to two groups: terrestrial television and terrestrial radio, which, because of the internet, have a increasingly unimportant sort of role in our society, in some people's opinion, right? Because all of this stuff can get distributed more efficiently over the internet instead. So that was a big question. So I'll break it into chunks for you, right? So first, what was Ronald Coase's idea about spectrum? And secondly, how do you see that sort of playing out over time with this resource that is maybe allocated to dying technologies, right?
Sure. Yeah, no. Coase is a major figure in 20th century economics. And you nailed it. He lit the way for what has become probably the most innovative public good allocation on the part of a government ever, which is FCC spectrum auctions. Right. So Coase's basic theorem was that where in a perfect world you could reduce transaction costs and you could assure perfect enforcement of the law, and if everybody was a perfectly rational, independent decision maker, the kind of traditional microeconomic assumptions.
Homo economicus, right? Yeah,
that exactly.
Yeah.
That humans and then people and then firms acting amongst themselves will make the most efficient use of any particular resource. Right? We don't need the government to decide how things will be put to use, right? So Coase took a look at how the U.S. handled spectrum, how the federal government handled spectrum. I think it was back in the 1950s. Mm-hmm. And what the FCC was doing was, spectrum then, Greg, in the radio frequencies was not considered, obsolete. Back then, it was where all the action was, right? So it was valuable to have broadcast spectrum rights. Old school radio broadcast spectrum rights and such. So the FCC had been granting these based on things like, which licensee would serve the public interest and which licensee would, make the best use of it. And that ended up, that led to a lot of randomness, a lot of inefficiency, and a lot of corruption. Right. And what he proposed was a system whereby, potential licensees, those firms which would use the spectrum, would competitively bid for it. Right. And the person who bid the most was probably the person who would put it to best use because they're willing to front the most money, know. And the other interesting thing about Coase, and you're going to see him come up again and again, is why you rightly cite him, is his main theory was about externalities. Right. Mm-hmm. So we think of an externality like, somebody's building a data center next to my house. Right. It's creating noise. It's an externality. Another is radio frequencies and electromagnetic spectrum with one another. So you don't use one that's close to another, right? And the FCC had kind of gotten into the weeds on regulating use so that nobody was disrupting anyone else's. The FCC wanted to make themselves a good spectrum neighbor. And what Coase said is you give them rights in their spectrum. They will work it out amongst themselves by paying off one another not to broadcast in one place or another so that the best and highest use of a particular band is being made.
Right. So you're interfering with me, but I don't need a sort of regulator to look at that spectrum and determine where the line is. We can sort it out based on mutual agreement or lawsuit if we have to or whatever, right? So.
That's right. Well, no, the whole idea there, Greg, is we don't want the lawsuits. They're too pricey.
Right. Yeah,
and sometimes the judge doesn't, so the right way to think about it, I think, is if me and you have, two bands right next to each other, okay, and we can't use them at the same time, right? But I am doing $100 worth of business revenue from mine, and you're doing 10 from yours. Now, rather than going to the FCC or a court and saying, "Hey, which of us should get to use this?" It would make more sense for me to pay you not only 10, but probably $15, and then take 85 to not use yours. Right? Private parties will bargain between one another, and one will pay the other to solve the externality problem. And Coase's whole theory is allow them to do that rather than have like a governing body make its own decisions about what's fair or have them try to manage the details. And society as a whole will get to use that spectrum more efficiently. And it's been a fabulous success.
So, yeah, that's what I was going to ask. So this is a rare case where an economist actually convinced some policymakers of something to some extent, right? Because we've had spectrum auctions.
Yeah, you know what he said? You know what he said? He said he said I will earn my lifelong salary after 1 year of how much more efficient and profitable this is for the taxpayers too.
Right.
But go ahead.
Well, yeah. So that's what I was going to ask. Is it strikes me, given my sort of initial setup of this conversation, that we maybe got some part of the way there, because I know there have been spectrum allocations that's been successful. Auctions, rather, spectrum auctions.
That's right.
But we're not yet in a world where I would think if we were in a sort of like completely sort of like transaction cost, low transaction cost kind of market, that we would have already seen T-Mobile and AT&T and Verizon buy this terrestrial television spectrum, but something is stopping them from doing that. All right.
So that more often to the protection of certain current uses that are grandfathered in from before these auctions.
Right, like television is a public good for communicating and stuff like that.
You nailed it.
Okay,
that's right.
Gotcha.
So, and whenever government, be it a court or the FCC or Congress, whenever they step in and say, with the power of the law, you're not allowed to do it, that guy gets to keep it, and that guy keeps it. And the difficulty there is that, it's not being put to what could be a way better use. Right. And that's why when in a free market, you allow parties to bid as much as possible rather than for a bureaucrat to dictate, you tend to get a better overall use of resources. And that's where Coase was coming from with his theory.
No, I think this is really interesting because like I said, if you just look at it from that, and of course, I get that there are issues with public communication, and it seems to me that a creative lawmaker could find sort of ways to account for that, and
you would think, but the problem is there's a long institutional and cultural history to a lot of these services. Right? Yeah, I think you would even find today actually. You should check it out, Greg. I bet you more and more of that spectrum space has been given over to auctions. It'll come eventually. Your concern over its inefficiency is undeniable.
Yeah. Eventually, terrestrial television won't be a thing, right? That's just going to take us a really long time to get there. And I get that there's steps that we need to take to ensure that public safety and communication are all accounted for or whatever. But
it's mostly a lot of stakeholders in the.
That's a great point.
Government and law enforcement, military, and moving them off of systems they've been on, is not easy.
And again, not to get too far into the weeds here, but it's this problem of the way that representational democracy works. That a congressperson is from a particular area where the person who owns the television spectrum in that area is often a major donor. It's same kind of things I remember reading about auto dealerships, right? Like as a similar thing where there's a real monopoly in that space because it's really easy as a very wealthy auto dealership owner to influence your particular congressperson, right? So it's like atomized across the United States.
For those, and they, in public choice theory in economics, right? They call that capture, right? So that's one of the concerns that critics of net neutrality type rules, for instance, have about an empowered FCC, or standard concerns over pursuit of public interest in Congress, which is that incumbents would always hope where they can to sit on assets that they've got or to throw up new rules that keep new entrants from presenting a choice. So Telecom reflects that in a lot of ways, telecom policy.
Right. Excellent. Well, Jeff, I kind of had wanted to get to data centers because that's where you're working now, and there's a whole thing, but we've run out of time. So I'm going to have you on again or something like that to do because I think we could probably
for your listeners. Coase's basic economic models that we were talking about usually involved land. Somebody building something that makes noise or smoke or something. So it's an apt field for application.
Yeah, exactly. I think we could talk about the data center issues for a whole episode in and of itself. So I think we'll maybe plan to do that sometime in the future. But just in terms of wrapping up today, I just want to. I always like to have folks look out into the near future.
Yeah.
What you've already really touched on this because it comes down to Loper Bright, if I said that right, and how it's all going to play out with Chevron and net neutrality. But anything to look at in the next few years of telecom law that you think is important.
No, like you said, I think we've already hit on it, which is that in telecommunications law and policy generally. I think that most have naturally grown accustomed to swing in policy that reflects changing administrations.
Right.
And we'll look forward into the years to come, not only toward possibly receiving a definitive read on some of these laws or how some of these laws are applied today, but one which kind of locks an agency in so that it doesn't get to go change its position when somebody gets elected. It'll make, the first precedent set in the years to come pretty important.
I remain a little skeptical that we'll get a big overhaul of the 96 Act, but that would be interesting to see as well. So,
Yeah. Well, maybe it's the last thing we need. Like you said, certain deficits in that one. Why repeat it?
Yeah.
Anyway, Greg, thank you very much for having me.
This has been great. If folks want to keep up with you, you don't blog or anything like that, but how might they find you, right? So
anyone who has any questions, follow-up corrections. If I've made any mistakes, I want to hear about it. Greg, it would take a lawyer to find some of them. But it's a Jeff at longandlongplc.com. So it's JFF at longandlongplc.com.
Thanks for listening. TeleGeography Explains the Internet comes from the experts here at TeleGeography. It's edited and produced by Jane Miller, and it's hosted by me, Greg Bryan. And I also wrote that theme song you're listening to right now. To learn more about our data, jump over to telegeography.com, and we'll see you on the internet.